You're welcome back, and it's still the key point. Now, this week has revealed the extent of the fragility in the relationship between the police and Parliament. Now, the source of this impasse is a demonstration at the Medina constituency, which we're told led to some destruction of property, burning of tires, and a road blockade. The Member of Parliament, Francis Xavier Sosu, who mobilized and led the demonstration, is being held to account. However, the police feel that they've been muscled out and decided to charge him to bring an end to a cat-and-mouse search. But will the Speaker release Mr. Sosu for court on Monday or cause him to be in contempt of court? All that and more we're discussing this morning on the Key Points. We're live on TV3, also on DSTV 279. It's also on 3FM 92.7. We're also live at 3news.com. Send your thoughts ahead via Twitter to TV3_Ghana, also to 3FM 92.7. You can also tweet at me. Happy to take your messages and read them. It's at Beho Bampo. Many thanks for joining us. Our guest this morning, Roxanne Dafiamakpo, the MP for South Dai. He's with me in the studio. And shortly, we'll definitely have the Director of Communications for the New Patriotic Party, Yao Boabin Asamoah, as well as UPSA Law Lecturer, Justice Abdullahi. But before we come to our studios, let's hear from the police. The Director General of Public Affairs, ACP Kwesi Ofori, has been speaking about the charges preferred against Honorable Sosu.
The latest is that the police have obtained criminal summons and have been duly served for him to appear in court on the 8th of November. As we enumerated, obstructing public highway, causing damage, among other things. The invitation has officially not come to the attention of the administration. But when that comes, the administration may take a firm decision.
So that's ACP Kwesi Ofori there talking about the formal service of charges against the Honorable Sosu. Well, some of the charges have to do with the violation of the Public Order Act, and we'll be coming down to details with that. But the minority in Parliament, the side to which Honorable Sosu belongs to, has been unhappy about how the police have gone about this whole rigmarole, where they've tried to arrest Mr. Sosu twice, once at the demonstration, a second time on Sunday while Mr. Sosu was worshipping at church. And the police had been summoned to face the Privileges Committee. However, they've gone this route. But one source of anger for the minority has been a lack of support from the majority, because this is a view that this could happen to any of the members of Parliament and has happened to MPs in the past. Let's hear from the Honorable Murtala Mohammed.
Many slippery statements issued by caucuses, at least under the 4th Republican Constitution and the parliaments that we have had. I have never seen such a slippery statement issued by this caucus. It is a statement that is pregnant with profound cowardice. That statement is not signed, so we do not know whether it is a proper statement coming from the majority caucus. And it's understandable why they refuse to sign the statement. They only provided numbers, and in this case, one number that is very clear is the number of Honorable Che Mensa Bonsu. What has suddenly changed? We have had members from the MPP who spoke in support of the position of the Speaker. Less than 24 hours. This is what is happening. My plea to the NPP caucus in Parliament is that they should understand that the framers of our Constitution and the principles of separation of powers is under attack by this very, very irresponsible act that they have engaged in. Read the content of it. It is convoluted. It is completely misleading, it is incomprehensible, and perhaps one thing that I can even identify in that rather reckless statement issued by the MPP caucus, denying a decision which was taken by the Speaker, that any attempt to attack the NDC in the matter of this will be resisted with all the blood we have in our veins. Let them get that very clear. And the IGP and the MPP, we are aware that the meetings they have had, and it is a rehearsal, arrest Sosu and go ahead to arrest other people within the NDC, including President Mahama. Anybody who tries that, the consequences will be uncontrollable.
Welcome back. So let's welcome to our studios the Honorable Roxanne Dafiamakpo. He's a member of Parliament for South Dai. He's also a lawyer and also a member of Parliament's Legal, Constitutional and Parliamentary Affairs Committee. Good morning, Honorable Dafiamakpo. Many thanks for joining us.
Good morning, Jifa. The name is Dafiamakpo.
Dafiamakpo. Okay, the
Yes.
F is deceptive for all of us, so I guess.
Yes. Because you know that we don't have that special F
true in every
the English alphabet. So.
Yes, that's true.
Yes,
so thank you for that.
And good morning to my good people in South Dai. Peki Kwali Kwevetongo.
Great. It's a beautiful area.
Yes,
I've had the opportunity to go through because of the Visit Volta campaign I've been on. It's been very much of an eye-opener, and I'm hoping that a lot more come out of it.
I know you were in Peki, you were at Villa Palacio, and I hope that during the phase 2 of this project, you visit South Dai, places like Germany, Chanakba. On the lake, we have very beautiful islands on the lake that can be incorporated into the tourism package for the VR.
Great, great. Yes. I think it's not going to end beyond the Volta Fair, which happens next week. So I think some of us are stuck with it for quite a while. So we'll keep at it.
You'll become our able ambassador. So.
Thank you. Thank you. Yes. And thanks for making it to the studio. This week has been quite a busy one in Parliament, and that's really been because of the conflict between, I don't want to say just Honorable Sosu, but it seems a section of Parliament and the police. To start with, what's the status of Mr. Sosu now? He's been formally invited, summoned to court, but has the Speaker released him to appear in court?
Thank you very much. First of all, I have been advising the police that if you look at 80% of our constitutional provisions, they are procedural constitutional provisions. Only about 20% are on substantive law. Because the Constitution tells you what to do. For instance, when the president intends to appoint persons to, say, the Supreme Court, there are procedures to follow. And they are outlined in the Constitution. To the Court of Appeal, there are procedures to follow. When the president intends to make nominations onto public boards, there are procedures to follow. When the president intends to, for instance, bring a budget to Parliament, there are procedures to follow. When the budget comes to Parliament, the Constitution defines the procedure we should follow in approving the budget. So, the constitutional procedural law are things that are supposed to guide and guard public officers in the delivery of the functions of their office. What is the issue? A member of Parliament is alleged, and the police have never said anything other than allegation, is alleged to have committed an offense, a misdemeanor, not a high offense, a misdemeanor. Indeed, an offense that Section 1 of the Public Order Act says, when it is established or determined by a court of law that indeed such an offense has occurred, it is the cost of whatever has been damaged that is supposed to be paid. It's a very simple provision. So I have even been hoping that the police would have established that this is the cost of damage caused to the public property in question. That alone should be the basis of all this. So you decide to invite the person. Then he invokes Article 117.
Parliamentary privilege.
Yes. So when he invokes that, what are you supposed to do? The other provision that you can have recourse to is in Article 1182. Some have argued that that is on witnessing, but But I have told them that in constitutional law, in interpreting constitutional provisions, you don't read the provisions in isolation. You read them as a whole. So the entire gamut of provisions under parliamentary immunity has to be read as a whole. The only provision that says that when a member of parliament is confronted with police arrest circumstances, and he invokes the fact that he is on his way to attending acts, or he is on his way from parliamentary activities, all you have to do is to give him the benefit of the doubt and come under Article 1182 and then have recourse to the Speaker. So that's why the Constitution says it is only the certificate of the Speaker asserting otherwise that the member indeed at the time and point when he was confronted with the police arrest or he was to be apprehended for the alleged commission of a crime against the Republic, he was at that time in the course of that time performing parliamentary duties on his way to attending that or from. And the Constitution is clear that that certificate is conclusive evidence of that matter. So they have agreed with me and gone to court because now they cannot, the arrest is becoming a problem. So one of the key alternatives to prosecuting crime is to issue criminal summons. So if a person is alleged to have committed a crime and the police are minded, they can conduct their own investigations without any arrest at all. Indeed, in a lot of developed democracies, that's what they do. You'll be in the house and criminal summons will be served on you, either through the post. That's the accredited means of serving court processes. You will receive criminal summons. When that happens, you now have to go to court to defend yourself. So now the police have gone to issue a criminal summons. That is good.
So the Speaker will not have to release him for him to respond to that criminal.
The Speaker has no role in this matter at all now. What will happen is that there are procedures again outlined in Article 117 as to service of the process. And if, with your permission, if I may read to the hearing of our viewers. Civil or criminal process, which in this case is the criminal summons, coming from any court or place out of Parliament, shall not be served on or executed in relation to the Speaker or a member or the clerk to Parliament while he is on his way to attending at or returning from any proceedings of Parliament. So this criminal summons will have to be served in accordance with this provision. And I think that there will be an opportunity for Sosu to be served. But I heard something very interesting from ACP Kwesifori. He actually said to the whole country that they've issued a criminal summons and the Honorable Sosu has been duly served. That is a blatant falsehood. So
you are saying that as of today, Honorable Sosu has not received any?
That is a blatant falsehood. The Honorable Sosu, as we speak, is on parliamentary duties outside of this country.
So he's not in Ghana?
No. He's likely to return perhaps tomorrow or Monday.
Maybe his aides have received the document.
You don't serve criminal summons on aides. Criminal summons, service of court processes are impersonal. They are to be served on the individual, on the party. And this is a criminal summons. In fact, particularly so in criminal matters. Because another cannot be responsible for the crimes of you. So, if I commit an offense, I am the person who is supposed to be held responsible, not another person. And that's our criminal jurisprudence. So, Sosu has not been served. He's not even available at the time when this was issued, let alone being available for the constitutional procedures outlined in 117 to be followed and served. Sometimes we need to be candid. There's a need for sincerity and candor from officialdom. It is good they have issued a criminal summons, which I have always been calling for. It is the duty of my brother to go to court to defend himself in the matter. And service is fundamental. It doesn't lie in the mouth of the police to say that he has been served. That is not how service is proved. Service will have to be proved by a bailiff of the court of competent jurisdiction that stays with the matter. So when there's no proof of service or the criminal summons on my brother, the matter will have to be adjourned to another date so that the registrar and the prosecution will ensure that proper service is effected so we can go into this matter on its merits.
All right. And you've been listening to the Honorable Dapiamapo. He has been explaining to us what the situation is with Honorable Sosu and the service made. News to us, certainly, that it seems that Honorable Sosu may not have been served. But let's hear Honorable Sosu earlier in the week when he put this issue before the Speaker.
Police officers under the command of the said ACP Isaac Kojo Asante, the Regional Operations Commander, and Eric Winfo, the Divisional Commander of Adenta Abokobi, led their boys to manhandle me and virtually held me and humiliated me right in the presence of my constituents with whom we were demanding for better roads. Together with the police, who had previously been notified under the Public Order Act, Mr. Speaker, we went through the road and I led the police to de-escalate and make sure that all the youth came under control until we all gathered at Otinibi, where we then proceeded on our demonstration under the leadership of the police and ended at Aimensa.
And you're welcome back. And that was the Honorable Sosu there when he put this before the Speaker earlier in the week. The Speaker then indicated that this would be referred to the Privileges Committee. And now that the matter has gone a criminal route, I guess that matter will be parked for now. But let's welcome the Honorable Yaobuabing Asamoah, who is the NPP's Director of Communications. Good morning, and you're welcome, sir.
Good morning.
All right. So I'll launch straight into you because I know you've been following the Honorable Dapiamapo's submissions. Certainly, it didn't have to come this far, did it?
Thank you for having me this morning, and a very good morning to
Yeah.
my brother.
It's been a while.
It's a troublesome.
Yeah, you look like an alien. You look like an alien.
I told you.
I was just hoping that wasn't coming.
It's coming. You know that it's coming his way.
These ones are fancy ducks, so don't mind.
Yeah, are they fancy ducks?
Yes,
ducked.
fancy ducks.
I've ducked. I'm avoiding your blows. Yes, but also a very good morning to your viewers across the world. I was listening to my brother, and I'm happy he landed on the note that, yes, the Honorable Sosu has to face the law.
No, he didn't land on that note.
He said that he should go and defend himself. That's what he said. So the question you're asking, did they have to come to this? And I am saying, yes, at some point, the system had to break down. Because the whole thing revolves around the ability to serve an MP. It's an extremely difficult process. You try serving an MP a process, election petition, whatever, and you will find that service is at the heart of the issue we are facing now. If it was a conclusive process, I believe that we wouldn't be having this problem. The constitutional provision that my brother read, I have it here, is literally being interpreted practically to mean that MPs are perpetually on their way to or from Parliament.
It's not as simple as that.
Exactly.
When I say it's not as simple as that, the MP performs legislative functions.
Can I land?
Representative functions.
Can I land? Can I land? That's why I'm saying that. It is important that it comes to this point. You asked whether did it have to come to, and I'm responding that yes, it had to come to this point.
Why?
Because it's not functional. It's not functional. Can we have a system where you have two different regimes of law running one group and another group? No, we are all equal before the law, rule of law. And so we must make it as effortless, as effective as possible for MPs, for other persons beyond and in other arms of government to be amenable to the law. That's what I'm saying. Now, if you look at what's happening in Parliament between the majority and the minority, the issues are coming out. Previous speakers have handled it in their own way. That means that provision is still subject to interpretation. That provision is still subject to interpretation. The statement says that previous speakers, Bamfordado and Doajaho, would invite you, do their own line of questioning, their lawyers as well, and then ask you to go and meet the relevant authority. Speaker, Right Honorable Michael Quay, would invite the police to the premises of the Parliament House. I have been a subject of an OSP investigation where officers from acting under the direction of Mr.
Citizen Vigilante
Came to interview me in the speaker's conference room, right? And now we have another ruling from Speaker Back. And the quotation is that Parliament is in session. You understand? And this is where you are now coming in with the different roles MPs perform. So should we leave it to the Speaker to determine when it happens and how it happens? Even though the Constitution hints at how it's supposed to happen. It says you cannot do it on the person's way to, from. You cannot. But it doesn't tell you when you can and how you can. That is where there's a gap that I think will be supremely dealt with by the Supreme Court. The police having followed up on their intention to file. If it's been filed, has it been filed? Has the police process in the Supreme Court been filed?
I'm not ACP question for it. I don't speak for the police.
Well,
but
you spoke for them somehow when you were hard on them right now.
No, I criticize them. But
so
that's in jest. I have no such information.
Yes. So it is important. The interpretative powers, jurisdiction of the Supreme Court is to make law based on clarifying the Constitution as we have it. You understand? If you have an ambiguity in the Constitution in terms of its operation, in terms of its understanding, then the Supreme Court can come in and say, well, on his way to, where does it start? When he steps out of the bathroom in the morning at home? And on his way from, where does it end? When he gets to his garage or after he leaves the presence of Parliament? You understand? Because if I'm from Parliament and you accost me at the Liberation roundabout, I'll tell you I'm from Parliament, so you can't serve it on me. But I am from Parliament. I've finished my duties for the day, preferably. But as you said, I may be on my way to meet chiefs in my constituency, and it is representative. I have to engage the people, and so I'm doing parliamentary work. So at what point is there space for the law as per the other enforcers of the law, the police, other jurisdictions, to engage an MP?
But didn't it also worsen because of how the police sought to approach it?
You see,
by forcibly trying to arrest him in church.
When
and we've been in this country where others have been arrested. They were not MPs in some instances arrested. It created a hue and cry and disaffection.
We've been in this country where gun ruled and we've progressed. We've been in this country where the judiciary was not independent and we've progressed. We've been in this country where there was no parliament, a single body was our parliament, our executive, and had control of the judiciary. And we've progressed. So that progress is what has informed the construct of the Constitution. That we are guarding against the past, the things that happened in the past to erode our freedoms. That is why we have this Constitution with elaborate provisions. You understand? But at stake now is how to construe that protection the Constitution gives us. It's at stake.
Certainly, it's not a total protection. There are limitations.
Yes, exactly. So where are the limitations? That's why I asked. If the provision is here, he just read, says that on his way to Parliament, from Parliament, where are the absolutes? Where are the limitations and all that? Because if I step out of the bathroom and I am told that there's a policeman at the gate with a summons, I'll say, tell him I'm dressing up and I'm on the way to Parliament. So I will not beat the policeman. I will evade service. You understand? And then when I finish from Parliament, and that is Parliament itself, and Parliament has to have a committee meeting in Sekuforidia, right? And I take off from Parliament to go home, change and park and all that. As I'm entering my house, there's a police van outside my house. I said, no, I can't accept this because I am rushing to pack my bag and travel to Koforidua on parliamentary business. So though I'm from Parliament, I'm actually still on my way to Parliament.
So for you, it's like an unending movement.
It's too broad.
Okay.
I think that the debate so far demonstrates the fact that no side is right so far. For me, that's and it is not a debate we should fear. There are those who are bringing the fear of something happening and not happening, but clearly, if it's not working, we should fix it.
Okay. Honorable Dapiamako, you wanted to make a point.
Yes, I want to rebut a few points that my senior brother raised. First of all, it is not correct that Speaker Gbagbin is not following the precedents set down by his predecessors. Indeed, Speaker Gbagbin was part of Speaker Michael Okoye's speakership. When we speak of speakership, it's the office. He was his second deputy. And like it said, it was not always the time. It was not always that we had Speaker Michael Okoye presiding. Sometimes he traveled for a couple of weeks or sometimes for days. And I can tell him that on the occasions that OSP was troubling him, the direction to have him speak with prosecution or whatever it was would have been done by Speaker Michael Okoye, Speaker Gbagbin as the second deputy speaker at the time, or first deputy speaker Joe Wise, in the absence of the substantive speaker. So these are functions of the speakership.
At the time, the substantive speaker was not there.
Sorry?
Was he not there?
No, I'm making the point
yes.
that he was part of the speakership of Speaker Michael Okoye. So some of these instructions, he's home to them. And he has continued. As we speak, there are about 13 or 14 MPs who are facing all sorts of police investigations and interactions. And they are happening in the conference room of the speaker. So Sosu's case may only be an additional one. These are matters of privilege. Otherwise, I could give names. But no, I could give names.
Don't give names.
Yes.
It's not right.
So it is not correct when the majority stated that Speaker Gbagbin is departing from established protocols. Let the record reflect that. Two, the constructive line or sentence in Article 117 of all the English preceding it is any proceedings of Parliament. So when a member of Parliament is on his way to attending at or on his way from, the controlling phrase there is any proceedings of Parliament. So what constitutes any proceedings of Parliament, Jifa? That is what we should be focusing on. When a member is involved, like he knows, we've served on the same committees. When we are in Kufuria, looking at the LI for brought by General Legal Counsel, we are obviously participating in the proceedings of Parliament because Parliament worked through its committees. So when we finish from Kufuor and I'm on my way home, what does it? No, I'm not smiling, but that is the law.
Your way home.
So you see, the issue is not about
You
whether
can be
or
served
not.
on your way home.
And let us be very clear: it's the same provision. It's not only in respect of MPs. It's in respect of the clerk to Parliament. It's in respect of the Speaker himself.
Yes.
When you have an unscrupulous executive who want to,
You are running too far.
no, I'm not running too fast.
Conclude.
Yes, I will conclude.
On the proceedings.
I will conclude.
You are leaving Kufuor.
Oh, hold on. So it's procedure. So the issue is not about whether or not an MP cannot be arrested. I've always made that point. It is whether or not the procedure to adopt in doing so.
We don't know what that procedure is.
No, we know.
What is the procedure? Because it now looks as if, depending on how the speaker views things. Yes, but the point is, depending on how the speaker views things, he may apply things in a certain way.
May I do this?
Yes, of course.
When you go to Article 110, Article 1110, with your permission, if I may read quickly. Subject to the provisions of this Constitution, Parliament may, by standing orders, regulates its own procedures. May. Now, he spoke of precedents. He spoke of established protocols.
Go to the standing orders.
Hold on.
After what you quoted,
Hold
the standing
on.
orders just repeat 117 and
yes,
118.
I make that point. But the constructive adjective there is that may. We may not have outlined this in our standing orders, but we have over the period established that when the police, you see, the essence of prosecution and whether or not somebody will be committed to stand trial, will not be a fugitive of justice, is whether or not the person will be available to stand trial. So where an elected member of Parliament is in the jurisdiction serving the interest of 100,000 people, he is not a flight risk. It's not possible that he will be a fugitive of justice. He will be available. So Constitution says there should be a different approach in dealing with that person. It is not about no equality of the law. There's equality of the law. He's been arraigned before court. And he cannot say that he will not attempt to court and answer for his charges.
So on Monday, will Honorable Sosu go, since you say he's not been...
No, if it's not served. If it's not served. Didn't the police say? Didn't the police just say? Hold on. Yes, I want that search to be conducted. Because Sosu, I can tell you on authority, is not within the jurisdiction. So if they say that he's been duly served, that cannot be correct. Didn't the police just say that the committer, the referral of the contempt that Sosu brought against the two police officers, didn't the police say that he has not come to their attention formally? What does the ACP concern for him means by he hasn't come to his attention formally? It means the clerk to Parliament is yet to draft the terms of that referral and serve them. That is what we call formal service, due process. So nobody will question that he's truly aware, but he's not acting. No, he says it is yet to come to the attention formally, and that is how we are supposed to conduct ourselves within the remit of the constitutional provisions. Let me conclude by saying that the Speaker's letter in question didn't also say that Parliament was in session in limine, was in session ad infinitum. He said, at the time, that fateful day, that you confronted the gentleman in Adenta in the course of the demonstration, and he says that
25th October.
Yes, and he says that he's just been informed as the deputy ranking of the Committee on Constitutional, Legal and Parliamentary Affairs to come to Parliament and deal with the matter because the committee was about meeting. So allow me to go. When I'm done, I'll submit myself. You said no. You were about to hand him. He was able to leave you. So Speaker said, at that particular time, Parliament, he was indeed in the business of Parliament. That is all that he said. He didn't say that you could not arrest him forever. He says that at that particular time when he confronted him. So Speaker was issued that certificate pursuant to Article 118. It is only his certificate to say. And Jifale, again, sometimes we need to offer the education. It says 1182 says the certificate of the speaker that a member or the clerk is attending the proceedings of parliament is conclusive evidence of attendance at parliament. So once the speaker confirms that when a member says I am attending the proceedings of parliament, he is indeed doing so, that is conclusive. It is no longer in doubt.
Okay, what I do want to ask though, once Mr. Sosu managed to get to parliament that day,
Yes.
nothing stopped him from going with his lawyer to meet with the police instead of making a formal complaint to parliament.
No, he made a formal complaint considering the conduct
Of the police.
So now he was proceeding under Article 122 because he says that under 122, conduct or omissions that will constitute contempt of parliament. So Sosu came to allege that the conduct of the two officers, in his opinion, constituted contumacious, a conduct that was contumacious of the powers of parliament. And the House agreed. So a referral was made to the Privileges Committee. So it is the Privileges Committee that will go into the merits or the demerits of the matter and make recommendations to the House to make a determination. And that is by it. Look, let me say this finally on this point. The principle underpinning parliamentary immunity is an ancient one. Look, when you have an unscrupulous executive who wields the executive powers of state and wants to come against you, they will break you. Let me give some examples. Lower down there. Assemblymen are constitutionally mandated to carry out their functions of office, constitutional functions, stated in our constitution. Members of parliament are members of district assemblies by constitutional stipulations. But we have seen evidence where executive use of state power prevented members of assembly from participating in assembly meetings. That is how terrible it can get. And let nobody confuse this matter, because you see, the same provisions that is protecting the MP is also protecting the speaker and the clerk. When the president logs 50 NDC MPs or 100 of them and leaves only 37 to go and consider his budget, you think he won't pass his budget this day and come back? So these provisions are set there for a purpose. It is a check on the executive use of state power by the executive.
Okay. Honorable Boabing.
See, Jifa, nobody in this debate so far has doubted the necessity of parliamentary immunities. Nobody. What is at stake is the ambit of that immunity.
Or the abuse of it.
The ambit includes abuse or effectiveness, utility or otherwise,
limitation.
and the relations with cognate institutions of state. They are all part of the administration of justice. The courts are part of the administration of justice. The police are part of the administration of justice. The immigration service, all those people are part of the administration of justice, to the extent that they also have lawful powers to enforce the law, as Parliament itself has given it. Now, that proceeding, I am having difficulty reading, but because of my brother Dafiamiko, I will read this again for his benefit, because he didn't answer the question. A civil or criminal process, this is 117, coming from any court or place out of Parliament, shall not be served on. It's a negative. Shall not. Or executed in relation to the Speaker or a member or the clerk to Parliament while he is on his way to attending at or returning from any proceedings of Parliament. So now you are returning from Koforidua on Sunday after a parliamentary session in a workshop in Koforidua. Can you be served when you get home? Because the following day you are supposed to go to Parliament. What is the time frame? Where are the gaps where it is stable it is reasonable.
Yeah,
it is
Parliament
safe.
is not contemplated as a physical location. In fact, Parliament is where Speaker determines.
I am happy at the way we are both going.
Yeah.
All I'm saying is that the current system is not satisfactory. Because it relies on the discretion
you want to
of the
abuse
speaker.
It is.
The speaker's certificate that you're speaking about, and the process by which that certificate is acquired, its sustenance, the limitations, time frame, if any. You understand what I'm saying? Yes. Those are matters that we have a police force now that is exhibited an intent to exercise its powers to the full. Now, that police force is seeking to engage, arrest, literally, an MP. And we have come up against this situation. It's been going on. Like you're saying, there are MPs now who are in the Speaker's Conference Hall being dealt with and all that. But the matter has come up. And why has it come up this way? Because it is obvious that the conventions, in the absence of 110, which he quoted, the Parliament may, in their orders, and I have the orders here, Parliament never executed those clear orders. They simply repeated provisions of 117 and 118. Yes. So there is.
But I made the point that
there isn't clarity.
So yeah, we use parliamentary practices
but,
and
but the practices are not holding up.
They are holding up.
They are not.
Otherwise, we wouldn't have this social
embarrassment.
No, the police.
You are saying the police are
the police. And yet they overlooked it to proceed against
the police are not satisfied.
They are not satisfied.
So yeah, they are also not satisfied.
No, by the constitutional provision in Article 1182, it is not up to the police to say they are satisfied. Constitution says that is conclusive.
Can you let me land? Can you let me?
So it's not up to you to say that I disagree.
That conclusiveness means that a speaker can shield an MP permanently from the law. Yes,
but there's no direct evidence of that.
And how long does the certificate last?
We've seen some MPs face the court.
So I yes, and I've said that I have been interrogated by officers of the OSC as an MP
by protocols established by the speakership.
And I am saying that let's consolidate those.
This kind of comments undermine speaker.
Let's consolidate those protocols in law. That the police are going to the Supreme Court is a good thing. That is where I'm taking this.
Supreme Court cannot enact laws or provisions for
Who said the Supreme Court cannot interpret the Constitution?
They can interpret.
So when they interpret the Constitution, the outcome is what? No, not law.
It's law.
The outcome is law.
It's law. But I'm saying Supreme Court cannot enact standing orders for Parliament.
It's not standing orders.
Why?
The Supreme Court is going to tell us
by
Article 185.
By legislation.
Are we not operating according to what the Supreme Court has
by
told
legislation.
Us? When we talk about international transactions, all that is there so far, the Balkan case and all that, we have not been able to pass the rules.
We are amending our standing orders. Yeah. You know we are amending our standing
order. It's a long process.
We will give the procedure.
You haven't
now we'll give the procedure.
So how soon will we see the amendment
to take care of this?
Our standing procedure.
I'm sure by December will be approved. It is always
December is next month.
The police cannot wait till December.
Oh yes, so they should go to court. They'll be overtaken by audience.
Exactly.
All right.
So the Supreme Court should be given the opportunity to engage.
There's no lacuna.
117.
There's no lacuna.
And tell us the time frames, the circumstances, the spaces for when an MP is proceeding, is going to or coming from proceedings of Parliament.
The only
and define proceedings of Parliament
they'll have
so
to place
that you can't say
define
that you
proceedings of Parliament. That's all that they have to define.
Oh, I told you he's a troublesome.
No, the only thing that Supreme Court may have to define is the proceedings of Parliament.
So don't I have
As for the other things, everything is clear.
Don't I have an opinion?
Attending at. Returning
okay,
from.
so when you are returning from Kofodi, are you attending to or attending?
No, so Supreme Court may have to explain what proceedings of Parliament means. That's all they have to do.
Thank you. So why are you arguing when you are coming to the conclusion that yes, the Supreme Court
no, but he did no.
He said
he agreed. He said the Supreme Court can interpret the provisions of the Constitution, but under the separation of powers, obviously they cannot be telling Parliament directly what their standing orders should be.
They are not telling Parliament what their standing orders should be. They are interpreting the law, and when the law comes out, it becomes the law. when the Supreme Court speaks in interpreting the
That's
Constitution,
true.
that is the law.
I agree.
It
That
goes
is true.
above
I
the
agree.
Constitution. Yes,
Yes.
That is jurisprudence.
There are examples of that law.
I am saying that the only thing the Supreme Court have to do.
This morning I didn't come.
Because you are frightening me. You look like an alien species. The only thing the Supreme Court have to do is to interpret proceedings, any proceedings of Parliament. What does that mean?
Very well.
Okay.
So the Supreme Court interprets any proceedings of Parliament, and then the Supreme Court tells us when you are going to and when you are coming from. When you are going to, where does it start? From your bathroom, your main gate, the runabout to Parliament, within the precincts of Parliament, the Supreme Court will tell us. When you are coming from, is it perpetual? Can you be served after you've left the place where the proceedings were taking place? Or you can insist that, I have another activity which is like a proceeding, so you can't. You understand? That is all the Supreme Court should do to help us. It will strengthen the Speaker's hand. It will clarify the role of the Speaker in terms of the certificate, and it will create clear timelines for the validity of the certificate itself. You understand what I'm saying? Yeah, so the law will illuminate that space for everybody. Then the police will be comfortable, MPs will be comfortable, and the citizenry will
also feel that,
that is the way to
there is
go.
no unfairness
That
in
is
the
the way
system.
to go.
All right. Let's take a quick break and then we'll be right back. Remember, it's the Key Points. You can follow us on Twitter, hashtag the Key Points. When we come back, I'll read some of your messages which have come through on Twitter. Thank you. And you're welcome back to the Key Points. Let's just read some of your messages. Eliasu from Tamale writes, what at all does the MP of Medina got to hide by avoiding the police? He must account for his stewardship as far as that demonstration that led to the destruction of public property is concerned. It's not in the interest of the Speaker to be confrontational with the police. Josh Niama writes, very interesting debate. Can we have this every week? Well, I don't know if Honorable Dafamapo and Honorable Boabin can come every week, but yes, they are quite an interesting
it's part of their parliamentary business.
This one
So
says, God bless
it.
both gentlemen. Papa J Jr. says, the Ghana Police Service and the government is not concerned about the grievances of the people with respect to the demonstration and are rather after the MP just because the MP led the demonstration. Kweku Abeku says, our MPs are funny. When the law is not on their side, then you hear them quoting the Constitution. How can you tell the police service you're on parliamentary duties at demonstration grounds? Well, the truth is, yes, when an MP is leading a demonstration on behalf of his people within that context, he's performing a representational role. And so he is working in the interest of Parliament. Baba Chairman writes, Article 118 is being overstretched by the NDC, going by their interpretation. No MP will ever be arrested if this continues. Musa Abatwa writes, the majority acted in bad faith. On the other hand, the police are embarking on a fishing expedition in relation to Honorable Sosu. They're just creating unnecessary tension in the public domain. I suspect unseen hands that are pushing them to go after the MP. And those were some of your messages. Thank you very much. We're also joined now by Justice Abdullahi. He's a lecturer at the Faculty of Law at the University of Professional Studies, Accra, popularly known as the UPSA. Mr. Abdullahi, thanks for coming in and welcome.
Thank you so much, Jifa.
So where do you stand? Do we amend or review the laws or the constitutional provisions on, parliamentary privilege, or this is just much ado about nothing?
Jiva, that's $1 million question. Indeed, I have had occasions to call parliamentary immunity as a Paleolithic concept, and that we do not need it in our present circumstances. And I think I still stand by that. And I say so on purely principled position. This whole parliamentary immunity thing started with the sort of protection that MPs needed in order to protect the realm. And the protection they needed was from the state, particularly the executive, because you can have an otherwise abusive executive and very uncharitable in all forms of it. And they use their majority to muzzle out the members of parliament in order for them to get their bills or other policies passed without the proper scrutiny that we deserve. Today, and today is not in reference to
what is happening with Honorable Sosu,
but today as in the 21st century, with all the democratic credentials, particularly if you even want to limit yourself to Ghana, I am wondering how the executive can legitimately intimidate members of parliament and succeed in doing so without the public coming after the executive. In other words, the public itself is the protector of members of parliament.
But
today.
Is that accurate? I mean, there are cases that agencies of state, and it may not just be the police. We've had the situation, for instance, with Honorable Mahama Ayariga, where the Office of Special Prosecutor, kept going after
It's still the
him.
executive, so you are still making my point.
Well,
So the position is,
for many people, when people think of the executive,
it's just the presidency.
Yes,
Voila.
it's just the presidency.
I do understand
Yes.
that, but we are not speaking to the ordinary person who doesn't understand the concept of the executive. And so that point should be made clear, that the executive here refers to all arms of the executive, all agencies of the executive. So where there are no legitimate grounds, as I was saying, for a member of parliament to be targeted, I see no reason why we should still maintain this kind of provision protecting the member of parliament, when the truth is the citizens themselves can do this kind of protection without necessarily having to have a problematic provision either in a constitution or any other statute. Now, that is the reason why I say that, because now what we have presently is that a member of parliament is even protected from his own constituents. So assuming Honorable Asamoah, as he sits here, takes this phone from me unlawfully, I cannot even go after him. Notwithstanding the fact that I am not the police, I am not a member of the executive, neither am I a member of any other institution. Why? Because if I decide to sue him, I cannot serve him. I have to go through series of procedures, protocols, before I can get him served, just to retrieve my own legitimate phone. I cannot. What kind of protection does he need from me? If he comes to you, if he buys your property...
But if there is a process, we should all follow due process.
Exactly why I'm saying that process is unnecessary at this moment. Because the person you need the protection from today is unable to inflict that harm on you. Now you have couched a protection that even protects you from the very person that you are representing. What is the essence of that? The person you are representing, not the executive that you are running away from. That's the kind of protection we have today. I can understand if you are running away from the executive because it is an abusive executive. But what about the individual in the street? How about the ordinary watch seller that you bought a watch and you fail to pay? That person cannot come after you. What did he do wrong?
But are you not looking at it in narrow terms?
No, actually, that's
parliamentary privilege is something that exists in various jurisdictions.
You are clearly not getting the point here.
No, I get the point, but let's talk about what happens elsewhere. Is Ghana really differing from what typically happens in other places?
Absolutely, we are relatively different. But I need you to get this point clear before we can move on to the comparative analysis. Now, the point here is that if you read the law, it has no limit as to the kind of protection that a member of parliament is getting, much as it is a procedural. But it's the kind of procedural provision that protects that member of parliament even from ordinary members, such that if they engage with an ordinary member in the street in any lawful transaction, that citizen, person in the street, cannot go after the member of parliament in question. So it is not just the executive or the police or even the OSP or any other institution. It is also, if his own wife cannot even go after him. His own family cannot even come after him. Why? Because he has that kind of procedural immunity that is so embracing that nothing can happen to a member of parliament. Now, this is the sort of provision that I'm saying that is unnecessary. If you would like to limit it to the sort of protection that we are looking at from the original intent, i.e. an abusive executive being refrained or being restrained from coming after the member of parliament, that may be a fair concept to argue. However, what about me, an individual? So, for instance, I have a contract, but I have had to come after a few members of parliament, maybe about 5 or more in the past. And just to serve them a writ of summons was almost an impossibility. Why would that be? You'd have to go through a series of channels, and sometimes it never happens. And now, after winning the case, even getting to execute it is impossible. So the question then is, and if you listen to the provision of the Constitution as they all read out to you, that's why I don't want to go back on it. It is couched such that there are no exceptions, whether it's from citizens or it's from the executive or it's even from Parliament itself or any other institution. There are no exceptions. All of us. This is why I say that it is unnecessary. And that is why I call it a Paleolithic concept. Completely not in tandem with the present circumstances. Now you bring in the issue of other jurisdictions. Other jurisdictions, even presidents are arrestable. Even presidents. This is what happens in other jurisdictions. Even sitting presidents, not just previous presidents. Sitting presidents are arrestable. So at what point in time what would be the sense in saying that if a president is arrestable, a member of parliament cannot be arrested? What kind of sense does that make? I don't get this particular concept. It's unnecessary. I do admit that indeed there are classes of protections afforded members of our society. I admit. But some of them are internationally imposed on us, like the diplomatic immunities. That one we can't do anything about. But those that we can afford to amend, there should be a way to look at it.
Honorable Dafemako.
And I heard all of them say that, we need a constitutional interpretation by the Supreme Court. It's fair. But why would we have to go all the way to the Supreme Court? That may take us about 6 months or a year in order to be able to interpret this provision, when the least Parliament can do, and which is a suggestion I would make, is to have that simple protocol with the security agencies. You can have a very simple protocol that going forward, if you intend arresting our members, let's go through this this form of procedure, rather than leaving it to the constitutional provision that all of us are having to interpret it in a way that is almost impossible for understanding, in fact, for consensus to be reached. If there was that kind of consensus built and a protocol established within between Parliament and all other members of all other stakeholders, i.e., the judiciary, the police, the Office of the Special Prosecutor, and all other institutions that may be connected with prosecution, that going forward, we believe that if you go by this particular channel and a memorandum is signed and agreed upon, I think it will take away all this form of ambiguity and determination of as to whether or not having a party in my house amounts to parliamentary business simply because I probably had a phone call from my member, from maybe the speaker or from someone else. Because indeed, at that moment that I'm having that kind of phone call, if it is indeed a parliamentary business, I'm engaging in a parliamentary duty. So you may probably not be able to arrest me. So if you go by that way, it will be almost an impossibility to arrest any member of parliament. And indeed, and that is a legitimate interpretation. You cannot take it away from my honorable member here, neither can you take it away from honorable. It's not possible. You can't take it away from them. The various interpretations that they are bringing on board are all legitimate. I can understand some may be absurd, but the truth is that it is a plausible interpretation to say that if I'm engaged in phone conversation with my constituents regarding a particular bill, or with my chief whip or any other person involving a particular parliamentary business, you cannot dispute the fact that I am engaged in parliamentary business. Okay. Now, if I'm engaged in parliamentary business and within that moment I run over someone, are you able to arrest me?
Okay, let's hear what Honorable Dafemako says, because I think we've been thinking about it, yes, within the context of the police and if there are any serious issues coming from the executive.
And that is rather a narrow one.
But what about ordinary citizens, Honorable Dafemako?
I am truly shocked.
You are scandalized.
Yes, by my brother Abdullah. First of all, he has a rather simplistic view of the doctrine underpinning the parliamentary immunity principle. Look, I said it earlier on that this is traceable to medieval times. And we have imported it appropriately so, and for good reasons, into our constitution. Jifa, let me say this. We have seen, and when we talk about parliament, now we are talking about the National Assembly. Parliament is an assemblage of the elected representatives of the people. So we have district parliaments. We call them district assemblies. In other places, they have other names. We have seen in this country, not yesterday, today, in 2021, November 2021, October 2021, Ghana, where the sheer use of executive power prevented the elected representatives of the people from participating and performing their legitimate constitutional duties in this country. It happened. Not in one place, not in two places, not in three places. It happened in so many places. To the extent that the constitutionally mandated performance of the function of a member of parliament at that level, he was stopped by gown-toting policemen. They told him that we know you are a member, but we will not allow you. Nobody spoke.
You're talking about district assembly.
Yes.
You have moved from parliament.
No, hold on. I laid the foundation. I said, when we speak of the National Assembly, we are speaking on the national scale. But parliament is only an assemblage of the elected representative of the people, constitutionally mandated. So the immunity that we speak of is not only in respect of MPs, but also key officers of such an assemblage, i.e. the speaker, i.e. the clerk. At our district assemblies, we have presiding members. Some were actually prevented from presiding. In fact, in many occasions, meeting venues were even moved to other places.
I don't know how this responds to the issues I raised.
Hold on.
The way you describe no, the way you describe.
Allow me to do this.
No.
Hold on.
So, Honorable Wabe, you have your
I was hoping that you are responding when you described my position as too simplistic.
Yes.
I was hoping that you bring out what makes it too simplistic. But I mean,
hold on.
this
I am attacking it.
Peripheral issues. These peripheral issues have nothing to do with the submissions I made.
They are core. I am trying to.
How does a speaker being a part of the protection team?
You said. Hold on. You said that in the 2021 Ghana, parliamentary immunity is absolutely not necessary.
Absolutely.
You said it.
Of course.
Hold on.
I have
hold on.
The same program
I am demonstrating that in the 2021 Ghana, there's massive abuse of executive use of state power against the elected representatives of the people.
He's talking about ordinary people.
Hold on, let me finish.
Okay, so let him put it through the pipe and let's hear.
You are a lawyer, just be patient. Not the
well, you were a lawyer when you were attacking Wabe. So you were a lawyer.
Not the rebuttal. So not the rebuttal.
I was here watching you attacking him.
Not the rebuttal.
Okay, so just allow him to finish.
Kept insisting that at least allow me because I was quiet when you were talking.
I am
and now you are rather crying.
Okay, so allow him to demonstrate.
It's shocking that he is crying wolf.
No, allow him to demonstrate.
I am demonstrating that.
Can you imagine this?
I am demonstrating that.
Please allow him to demonstrate.
So unbelievable.
I am demonstrating that this executive is guilty of using state power.
The current government.
Yes. Is guilty of using state power.
Well, the usual MPP and NDC.
That has nothing to do with you are
nothing to do with my position.
I am demonstrating
just allow him to finish.
The grant of parliamentary immunity.
Please just allow him to finish. I will allow you.
It is dangerous when
I
a
will
person describes
this segment.
Simplistic, and yes,
it is
provides
you the basis.
Okay, I have to extend this segment because of you, Honorable Mr.
I'm not interjecting anymore.
Okay, so just allow him. Yes.
I am demonstrating that in the 2021 Ghana, the executive is guilty of demonstrating abuse of state power to prevent the elected representatives of the people from performing their constitutional duties. So the grant of parliamentary immunity to the elected representatives of the people at the national level, it is so important even of now than before. because there's a demonstration of abuse, of restraining the people, preventing them, and locking them from performing their constitutional duties at the local level. So when you have such an executive, you can't say that the presence of provisions on parliamentary immunity in our constitution is needless.
Okay, so how about the example he gave? An honorable member murders my family member.
Let me deal with that.
How do I then deal with that?
I have made the point that it is not about whether or not an MP cannot be arrested. That is not the issue. It is.
So an MP can be arrested.
An MP can be arrested. That's what I saying.
So how do I arrest the MP?
No. That is what.
Missing the point.
I'm not missing the point. Those are the things you have said. I've noted them down.
Okay.
So let me finish. Let me finish. Note yours down. So I am saying that it is the procedure. He mentioned the point that even private persons cannot serve a court process on an MP, and I was scandalized by that, because he knows that where you can demonstrate to a court that I have used all the legitimate means to serve a process on an MP, and I have been unable to do so, there's something we call substituted service. The court will grant you. Yes.
The court can grant substituted service against an MP.
Of course.
So that
of course, where you demonstrate. No. Because you've created the impression that it is impossible, and I'm saying no, it is possible. Possible
but very difficult.
No, look, there's difficulty in everything.
No, please.
Wow. No, hold on.
If I commit a crime, I'll be caught quickly.
Jifa, you will be caught quickly.
Yes.
Especially when it is in flagrante delicto. I've made the point that when an MP is caught committing a crime, I think in my humblest opinion, the immunity evaporates. When you are committing a crime in flagrante delicto, the immunity will evaporate.
And where is it stated?
Sorry?
It is your view.
It is my view, and I humbly hold it. But where there is an allegation, you understand? Because when you are committing a crime, Parliament doesn't commit a crime. The constitutional provision says proceedings of Parliament.
But I thought so.
Hold on.
Parliament, you cannot be chased.
Hold on. Did you read the police statement? They said when they attempted to arrest him, he invoked parliamentary immunity. That is what is very important. If you are kept quiet, he would have been whisked away. So when the person invokes parliamentary immunity, you go to 1182 to let the speaker certify. So when you are committing a crime, speaker will say that when you are committing a crime, you are in the course of performing parliamentary duty. Parliament doesn't commit crime. We are not in the business of committing a crime. That is why, in my humble opinion, when an MP, when you overspeed on the road and you knock somebody down and police arrest you, you can't say that.
You can say I was rushing to Parliament.
Yes,
I'm going
so
to
Speaker will clarify that. But
so
by that time,
and go to Parliament, clarify.
No, the Speaker will have to clarify.
So by that time, the person has left.
That is why I said, in flagrante delicto, you have committed. You are caught committing the act.
But if you hit and run, you are in a.
Oh no, that is after the offence. So that is
but can you arrest somebody before he runs over another person?
That is why I said in flagrante delicto. Bam, you knock the person.
Now he's amenable to arrest without the speaker's certificate.
I am saying.
Then he knocks the person down and rushes to Parliament and enters the yard.
Yes,
you have to chase the speaker.
You see the absurdities
absurdity.
These are the absurdities that I was referring to.
About absurdity. Let me clarify.
Okay, but you see, the other thing that may also be used as criticism against Parliament, when in this country where a member of Parliament was allegedly convicted of drugs smuggling, that person's seat was kept until that full case was determined.
I don't.
The MP from Nkranza at the time.
No, he was outside of the jurisdiction.
Yes, but he had been convicted for a crime. Yet the House, the decision was to hold on to his seat until that whole case ended.
You see,
so
our laws are not applicable in America. You understand? So you can address that, because that is in respect of their government, their people.
Can you imagine?
But let me say this. Let me say the point is that Abdullahi got it wrong when he says that you cannot. It's impossible to serve a court process on an MP or speaker or a clerk. I am saying our rules of court permit you to go by statutory service.
If you demonstrate that.
If you demonstrate that I have.
Then we are going to see a lot of statutory services
If you demonstrate
going forward.
that I have exhausted the procedure under 117, and yet I have not been able to serve the party in question. Okay. And therefore, I pray the court to grant me to do so by statutory service. In fact, that is the essence of statutory service. Difficulty in service.
Yes, Honorable Boadi.
There's been a broad generalization stated here, which is really unfair to the government, to say that people were prevented from exercising their constitutional mandate and then to broaden it across the country and typify that. It's not fair.
That's
Please.
what the government has
When you make such a thing, you must particularize. It is not
okay,
fair.
let me advance you.
No, we don't have to go. I'm just stating the point.
I'll mention Takwa.
Bring the evidence.
What are you saying?
And serve it on the speaker. Bring the evidence and serve it on the speaker.
There's one rolling on
now,
the screen.
The second thing is that when I began my submission, I said at the center of this is the difficulty of service. Service. Coupled, because it derives from this whole notion of to
and from, which is not fully defined.
Which is not, is unlimited. To and from. So it is very, very difficult to serve an honorable member. And I must say that Fiamepo, going to substituted service is not the solution.
It is.
If you have to demonstrate that the original process has failed, then it's not the solution. The original process must be amenable.
Yes.
It must be
fairly
certain.
You should ask him how did he attempt to serve the members.
It must be straightforward.
He should be telling us how he attempted to serve the members.
He will tell us.
Pursuant to 117, and he failed.
He's a lawyer.
He has raised a major
not allowing honorable.
He has raised a major point.
You mean Mr. Abdullahi?
If the police, with all the authority and power at their command, are having difficulties serving MPs, how much more a private citizen? He has made a major point.
It's not the watching seller.
A serious point.
It is the court that says.
So it is important.
It is the court that will demonstrate.
It is important.
You are still a lawyer. Remember that.
It is important for consolidation of the democracy we are building, that these lacunae are dealt with. Parliamentary immunity. When he says medieval times, perhaps he should have explained better. It's a direct impact of the growth of parliamentary democracy from the UK.
Yes.
Right from the beginning. When kings started with divine right.
I have shown that
God
is
put them
preventing
there.
people from attending.
God put them there.
I've demonstrated that.
You are not doing the right thing. God put them there.
Jiva, next time,
so they were not subject to any.
No, I'm coming to you.
They're not subject to
any
human authority. Then it got to the point that they needed human support to get some of their things done, particularly their sustenance, taxation. They needed to collect money. You can only extort money from the people for so long. It got to the point where the people simply would not. So then you had to bring the people's representatives to help you to sort out the taxation, to conscript people to go and fight for you and all that. So it led to a process of meetings. And these meetings grew into the parliament. Now, in those meetings,
they could just take out those who don't want to approve those things and push what they want.
It got to the point where, in the beginning, you are calling a meeting. You are calling a meeting based on the people
who you like or those who like you or support you.
And then within those meetings, factions started forming, and that's what led to the parties, the factions. So the leadership, when they depended on one faction to support the kings, to support what they needed, then they would come down hard on the other faction. So parliamentary immunity grew. That once you were on the business of parliament, the executive could not stop you. It's grown over the years, it's mutated, and we have the modern version here. I don't think, I don't agree with Justice when he says we don't need it.
We don't need any parliamentary immunity.
Yes, we do.
We need some of it.
We do. But I insist that the police have done the right thing by going to court to have it clarified, so that what I agree with Justice on about even ordinary people, so that I, as private citizen Yabo Abia Samoa, I have a problem with Dafiamepo on his wild assertions against the government, defaming the government. I can sue him for defaming the government, and then I can walk to Parliament, and there's a unit there.
Did you see Joabi Assemblyman kneeling down?
Okay, but that doesn't really count, because at the end of the day, they still went and voted against.
Let's not divert the conversation. Let's not divert.
I don't know why Roxanne is trying to divert the whole thing.
I should be able to go to Parliament. I should be able to go to Parliament and go to a place there and have service relatively easily done for legitimate reason, because I have a right I need to execute on that member. And that right deserves as much protection as the member's right to represent me, which immunity grants him. So if we don't clarify the rules and we wait on the speaker's say so, then we are riding into a situation where that discretion, even though stated in the Constitution, is so ambiguous that the speaker may be misconstrued, as we are facing now. Because it says the speaker's certificate, and he brought his own judgment on that. I'm on my way to Parliament. I'm in a hurry, and I cross a red light with my sirens flashing. I have a big car, and then boom, I knock down a motorbike who is green, and then because I'm in a hurry, I go to Parliament. Now the police are looking for me, and they come to Parliament. They say, "Oh no, he's in proceedings, so he cannot be arrested, even though he's just committed murder." Manslaughter, for that matter. It wasn't deliberate. See, proceedings or reckless driving or negligence or whatever they want to charge me with, but you can't get to him. Now he is saying that if in knocking the person down, the MP was gracious enough to stop, then his immunities are stripped away because he stopped.
Submit himself.
His immunities.
But if he doesn't submit
himself,
then he cannot do anything.
It is ridiculous. It is absolutely ridiculous.
It is absolutely ridiculous.
No, but that is what the law doesn't say. Use immunity to run away from the consequences of your actions.
No,
the law doesn't say use immunity. The law doesn't say use immunity to run away.
So I think Honorable Wabi has made that.
It is critically necessary that we define the access rules. And I don't think that agreement amongst the various, by way of MOU and all that, can do it better than
MOU
a Supreme Court,
setting
it out
on
clearly.
This. Justice.
And they will not be imposing on Parliament. They will be executing
instead of talking of standing
their
on
mandate.
MOU. What is the place
of so Justice, so the police,
when the court pronounces, you can put it in the new standing.
Okay, so Justice, the police have gone to court. We are not sure when we'll actually hear anything on the scene, as it takes some time for cases to get through the Supreme Court.
They go to court what? They say they intend to.
They intend to.
It's a mere declaration of intent.
If they are not yet in court, I want to insist that they should go immediately.
In fact, I will go.
Okay. But you nowadays you are beating a path. You are using your 137 to beat a path to the court.
So Justice, so your
substantive, procedural.
I'll leave him to Samukujo too.
Okay, so
that's why I leave him.
So your final point on that, yeah.
The good part is that both honorable members, directly or indirectly, agree to my position that we do not need protection from the private citizen. Much as Roxanne would like to put it in a different way and insist on some form of lawlessness, that unless an honorable member submits himself,
I don't think he's calling for laws. That's why he said the police can arrest once you are caught in the act.
I spoke law. I said inflagrante delicto. If you invoke 117,
so
let me get a problem.
Explain inflagrante delicto to our viewers.
You said in
the act.
Your newfound love of the Supreme Court is now in
Latin. They say you are on your way to Parliament. If you are caught among armed robbers robbing,
if you are not caught and you are identified,
okay,
when you get to Parliament, they cannot.
Hold on. So, Justice, why are you not also giving whoever might be the speaker the benefit of the doubt that they would look on the issue, and if it's a criminal matter, they know it's a criminal matter, and they will not shield such an individual?
That's why I said that the protocols should be redefined, such that if you are discussing immunity it should be purely, I mean, we should distinguish that the form of immunity we have today, as I said, is too all-embracing. So we should distinguish that from that kind of immunity that you need from the state, which is what Honorable Bobby just said, that assuming you are dealing with the individual, a private citizen, there should be a different protocol as against dealing
so
with the state.
So maybe in review of standing orders, there might be exceptions.
Exactly the point that I made.
There might be exceptions.
Because as it stands now, an individual cannot go after an honorable member without going through all the difficulties that Roxanne doesn't want to admit.
Okay, but let me ask you something about the honorable. But let me ask you something about the honorable Sosu. As of yesterday, we know contractors are on site at the Kwame and Damfa Road to deal with the issues that were raised. So, isn't it just evidence that when people don't actually step out, raise these issues, government does not...
The contract has been out there long.
Yes, but the contractor hasn't done. So he's been there yesterday, only a week after the demonstration.
Hey, that's your
how do you explain that? No.
But
it commingles, yes, so to speak. So, Honorable Boabing, the fact that even the contractor is there means that if the people had continued to keep quiet, there will be no work.
There. That is a question that seeks to justify an unlawful conduct.
At all.
If the question is that demonstration
an allegation of unlawful conduct.
Okay.
Allegation of unlawful conduct.
Well, I think eventually we get to know.
Well, we have to.
So,
yes,
now,
because no one has actually shown us which properties were destroyed. To be honest, the burning tires, yes, we've seen, but the destruction of property, we are yet to.
I think there was also
and the law says that they must
yes.
There are many projects going on, including Adenta, major road projects that were not initiated through demonstrations. It is not the most preferred form of seeking action on developmental issues.
Peaceful demonstrations. Yeah. Today you deride the importance of peaceful demonstrations.
I'm not talking about peaceful demonstrations.
Yes, it's supposed to be
exhibiting
No. She said that the demonstration on that road has led to the contractor coming. I'm restricting myself to development projects.
Yeah, the contract has been the contractor abandoned site for non-payment.
No. It's not for non-payment.
He said it wasn't for non-payment. The MCE told me that it was because the rains had come so heavily and all that. Once the rains stopped, the contractor
was citing, not payment. He said his
material condition precedent.
Yeah, he said his materials were site card.
So this matter to condition precedent.
Let me allow justice. Yes, so justice. You said there is no excuse for alleged lawless behavior.
So, Jifa, my point is that demonstrations are good. Particularly if it's against an MPP or an NDC government, it's very good.
Any government?
Well, they are the only government
we've had so far.
So long as you have demonstration against either of these parties, I love it. However bad it may be, so long as you do not engage in unlawfulness, because a peaceful demonstration is what we yearn to achieve. It's part of a good democratic credential for a country to, for the citizens to engage in proper demonstrations. That was drum home the position that they seek to address, but it shouldn't be intermingled with any form of unlawfulness.
Okay.
And naturally, we shouldn't expect the police to also come demonstrated with that kind of hard-handedness that they do, maiming people and sometimes to the extent of killing others. I think that is not what we need in this country.
But is it fair to hold Honorable Sosu responsible for people's anger?
He should answer for it. It's as simple as that.
He should answer for it.
Yeah, he would
the police should identify. It's almost as if he's an easy target.
No.
Why not identify the citizens who bend on time?
The rules say leaders of demonstrations are responsible. That's what the rules say.
But that was the point I was going to make anyway. When you engage in class actions, it's always the leaders that are held liable, because it's believed that once you take out the leadership, the members usually would disperse and things can easily die. And so it works with demonstration and other things as well. So it's always the case that the identifiable ones will be the victims rather than the other members. The other members, some of them may even be used as witnesses if need be. And so it works that way. And it's not unfair. It is just what it is. If the police can arrest more, of course, they would have to do that rather than just, being on a target witch hunters, sometimes you would probably want to call it. But Jifa, that aside, I think, I've made the point that Sosu and his people could have made this demonstration a very good one. In fact, I was fully in support of that. I was hoping that the Domingo Amenya areas would also engage in similar demonstrations, because I think we are possibly the hardest hit when it comes to bad road within Ghana.
I live there. It's terrible.
Welcome.
There's lots of asphalt that you are enjoying now. Lots of asphalt.
I don't want to get into that debate now.
It is where he probably lives.
No, he doesn't live there.
I know he doesn't live there. But how else would I put it?
asphalt.
That's the only mischief I can.
But in terms of
when
he's appearing in court on Monday.
Hopefully.
Honorable Dafia Makpo tells us he's outside the jurisdiction, and so the claim by the police that he's been duly served cannot be accurate. What do you see happening on Monday?
I don't think he's a lawyer for Honorable Sosu. So anything he
but
says
they
at
are
this
in
moment.
close communication. They are close-knit group.
Yes.
He's always doing his cases jointly and severally with Honorable Sosu.
I'll take whatever he says with regards to that, with some level of exceptions, because really what is said in court is different from what is said on TV3 or any other network, because it cannot be held against him in case it gets to be false. And so I think we should be very circumspect with that. On Monday, if he doesn't appear in court, I think the police would have to justify, in fact, they would have to prove that indeed they served him. And there would usually be some form of proof of service. If they indeed have that, they can obtain a bench warrant for the arrest of Sosu if they're able to establish it. However, if you're unable to do so, the court will give them yet another opportunity to attend service, and they'll keep doing that. And now that comes back to the same issue that I was raising. If the whole Ghana police service is struggling to get a member of parliament served, imagine, Jifa, you and I being involved with Roxanne here, and maybe probably takes your phone and you intend getting your phone back, the difficulty that you would have to go through. And he says that is still normal, because today he's a member of parliament. Obviously, I expect him to maintain that position. But at least, as for Yawaben, he has been very honest about it. That it is not that joke. It's not a joke, as Sam Okujeto will say. It's never a joke to have an issue with a member of parliament and not have any means of exacting your pound of flesh, as it were. It's that difficult. And I see it's so needless to go through such processes between you and your member of parliament. And I was citing the example of even a husband and a wife. If one happens to be a member of parliament and you intend divorcing your husband, who is a member of parliament, that's where you smell pepper. At that moment, you understand this position that I'm making, because if you have to, a person that you live in the same room with, you can't even get him to serve him, simply because he's a member of parliament. Imagine what others would go through. And so if
when he's in his pajamas, he's not on his way to parliament.
Unfortunately, when he's in his pajamas, the bailiff cannot come there and serve. Unfortunately. See, these are genuine difficulties that today you don't want to wish away that it doesn't exist. But that's still fair, because he's an NDC member of parliament today. Tomorrow, I'm sure when he becomes an NDC.
I'll let you rebut. Please go ahead. Because I saw that you took. So that will be your final point on this subject. And I'll take Honorable.
No, Abdullah.
You were bribing me earlier.
No, I wasn't bribing you. I take strong exception to the point that today, because I'm an NDC member.
That one is withdrawn. That one is wrong. That one is
very wrong.
Oh, it is withdrawn.
But
you're my brother. If I say that, you should know.
But it's totally needless.
Right.
Law is law.
Surely.
So let's talk law. There's a whole provision in our court rules on statutory service. A whole provision. And there's a whole jurisprudence on that. Service generally can be problematic, even between private person and another private person. Buy today's Daily Graphic or Times and see the number of processes that have been publicized,
advertised in the paper
by way of statutory service. So that is not a fair comment on me. I'm only saying that there is procedure under law, under statutory laws, under constitutional law. Constitution says when you have an issue with the clerk to parliament, speaker himself or a member of parliament follow a certain procedure. The same law allows you, or there's a constitutional instrument that allows you that when you have difficulty in serving a court process, which could be a civil process or a criminal process, do so by substituted service. There are grounds upon which you proceed and persuade the court to grant you that. So how is that coming? How is that as a result of the fact that I'm advocating so because today I'm a lawyer and I'm in Parliament and I'm an NDC1? No. I am only saying when it is difficult to serve, even private individuals, the court permits you to do so. And the person saying it can no longer say, I am in the process of performing parliamentary duties. You have to go and answer by any means necessary. That is why
can the MP ignore the substituted service? They can say they've not seen it.
There are consequences. There are judicial consequences.
Which is the bench warrant to be issued for your arrest.
Even in civil process. I will not even go to criminal process. Civil process, there are consequences. You can be exerted in court. And costs can be very punitive. So we are governed by laws. So you can't say that because there's a certain constitutional provision or an immunity from some immunity from service, when that has been exhausted, and you were still not available to be at the receiving end, the court cannot proceed. The court will, in fact, the court can even enter judgment when you don't enter appearance. All those things are available.
So you encourage people to go according to the process.
Procedure. It's as simple as that.
Okay. Honorable Boabe, your final point on
Have you ever been fortunate enough to be part of a school demonstration where you broke a few windows and damaged the school?
No,
bus?
my grandmother advised me
me.
long time to stay away from all, even in university, Mobrowa demonstrations. Don't join any.
They determine the cost and then they bill every student.
The ringleaders are isolated and dealt with drastically. Sometimes expulsions and then the majority are left behind. So Sosu is not being targeted per se. Let's not reduce it to that kind of situation. And then, substituted service is a last resort process. And it is expensive. You know how much it costs to publish something in the newspapers?
But you can get that in cost. That is why cost is costing the cost.
Please.
The court will take advantage. You are making an economic argument now.
So because of that, you have also made this procedural argument. So I am not allowed to make economic arguments. I am saying that I have made a legal point that substituted service is not the first option. That's a legal argument.
But I've made a point. It's the same point I've made.
Yes, but so you can't process it as if it's of choice.
No,
people get there because they are frustrated. Let me land.
If you exhaust,
we don't have all day.
Okay, so let him land because
that exhaustion is the worst you can get through. That's the point we are all making here. That it is not clear. The procedure is obscure. It is stated in the Constitution, but it is so dependent on the discretion of the Speaker, and therefore it could do with better clarification rather than keep that struggle and then go and pay for substituted service. Why don't we reform the process so it's easily accessible? Everybody knows what will happen. Everybody knows how the Speaker will react. The Speaker can even delegate his powers to a clerk and have a stamp on it as a Speaker. You appear there based on the classification of the case you have brought. It is processed in this manner. You go home and you know that within a day or two or whatever, you will get your MP to respond, either in court or to the police for questioning. That is all we are saying. Yes, there's a procedure, but to the extent that we are having this conversation, and this conversation has gripped this nation for the past week, there's lacuna that we must deal with. And for me, the best option when you have a written constitution is to interpret it. If you find that there are gaps in the constitution, interpret it. So police, please, you've evinced an intent to go to the Supreme Court. Follow up on that intent. Go to the Supreme Court and let the Supreme Court clarify in terms of service what going to, coming from, and proceedings mean.
And then Parliament can also make amendments to its standing orders.
Once the rules are set out, Parliament can adopt them if they so wish. Or if they don't, they can always refer, or individuals can always refer to those rules as the rules. It's just like Article 185 on the international agreements.
Yes.
Parliament is supposed to have created rules and passed a law on the whole space. They haven't. So it's gone all the way to the Supreme Court. And now anybody who has a problem with an international agreement quotes the Supreme Court's diktat from the Balkan case. It is law. And it impacts Parliament. MPs have gone to court on the basis of that. So you can't say that when the Supreme Court pronounces, it is imposing on Parliament. No, it is only important that that clarity comes to the rules that Parliament itself is relying on now. Because all Parliament is relying on now, and the Affirm is very strong about process, is what is in the Constitution and what is in the standing orders. The standing orders merely regurgitate Articles 117 and 118 in there. It doesn't clarify them, it doesn't stabilize the situation, it doesn't tell the circumstances for the issue of the certificate and all that. So it is important that the police serve the nation well, the way they are going, by using this Sosu, Honorable Sosu's case as a test to get finality to this service process.
Finally,
finally. So enough. 1 minute, yes,
30 seconds,
because we need to move.
The executive exercise of powers of state at the local level to prevent elected members.
I don't think it's
a
fair.
reflection.
I don't think it's fair.
It's a reflection
to
of the microcosm.
I don't think it's fair to make those conclusions. The first time you started, I just kept quiet and let you speak. It is not right to make those generalizations and conclude that there is something that the state, this government is responsible for. I don't accept that. It is not fair. It is not fair.
Let's
not part of this discussion, and I will not accept the position you are going. It is not right.
Demonstrated an abuse of executive.
Who has demonstrated what?
Thank you very much.
Nobody has demonstrated anything.
You have stopped assemblymen from working
about
in this country.
The case of Sosu versus the police. Whether we've gone beyond bounds on this. And we'll be moving to our next topic, which has to do with digitalizing Ghana. The Vice President has been giving updates on how far we've come over the last 5 years. We take a break and we'll be right back. You're welcome back, and it's still the key points. Many thanks to all of you who've been sending us messages via Twitter. Do feel free to send us more and I'll read them out. Our next issue is about digitalizing Ghana. Real impactful transformational change or a short-term quick fix? Well, 5 days ago, Vice President Bawumia updated the country on progress to achieving a digital economy. The Vice President referenced extending digital platforms in the Ghanaian government sector to allow for effective purchase of goods and services and access, leveraging on the NIA's registration, as well as digital support for land, property, health, education, and tax management. However, there's been some criticism of the Vice President, and the view is that this is not his job. It's the job of the Minister for Communications and Digitalization. Is it wrong for the Vice President to be high profile leading this charge? Or should he rather be accounting on the economy to the people of Ghana? And I'm still here with my guest, the MP for South Dai, to our far left, the Honorable Roxanne Dapiamakpo, and also to my immediate left, the Director of Communications for the New Patriotic Party, Yao Boabin Asamoah. And I'll start with him on that last question. Why is the Vice President doing this? Prior to election 2017, he was well known giving lectures about the economy, telling us what the results, what the solutions will be. 5 years down the line, he has become a digitalization champion. Some feel that is the job of the communications minister, not his. What are your thoughts on that? Or what are the party's thoughts on that?
Okay. If I let me first congratulate His Excellency, the Vice President. I mean, he's a brilliant man by all standards. His governance, his economics, as you say, and in particular his execution. more often than not, as Ghanaians, we are long on speech and short on implementation. And for me, what he has achieved and he shared with us was an eye-opener to all of us. It was the implementation that made me sit up. Even I, as Director of Communications for the party, I was yet to link all the dots in terms of the system-wide effort to underpin the economy and grow it in a more holistic manner, in tandem, in tune with the international world. So, implementation. And we need to accept that not everybody is participating in the economy we even have now. We need to accept that. We need to also accept that many people still suffer the danger of waking up thinking about how they are going to get the next meal in terms of using their hands, using their brains, using their energy, their effort to churn out something that is tradable or immediately edible for themselves. But how do you move that society to a level where more and more people can be included in the process of the bread and butter matters? And I think what the Vice President is championing goes to the heart of that. This is not as if we haven't had digitization and digitalization before. And I understand that the two are different.
Yes.
Digitization is the process of mobilizing and assembling the data. And then digitalization is operationalizing the data to achieve the ends that you seek. So in some stages, we are at digitization.